It certainly was my impression that we were talking about video of the entire episode, and not that it certainly in my mind was not limited to the specific numbers on this observation point list that you're talking about. I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to say.
I have to say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order. Yesterday, as I said, I was under the court's ire.
You know, I don't want to talk about...
Well,
why don't we
I think it's a fundamental fairness issue, Your Honor.
All right, say what you want to say.
If I'm being held to obey the court's orders, I'm asking that the defense be held to that too. This is...
Welcome back. Judge Bruce Schroeder has emerged as one of the...
Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. And with all candor, I was not even aware that Reverend Jackson was in the courtroom until you started your motion. I have indicated the court's position. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention. And I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial. And I will continue to...
Controversial. This is the sixth count, the gun possession by a minor charge. The judge just dismissed that count. And the reason being is that there was a discussion happening as the defense and the prosecution were waiting to go into jury instructions. The defense was arguing that the state statute here in Wisconsin makes it illegal for minors to carry a handgun or a short-barreled shotgun or rifle. The statute apparently is written to allow teenagers to go hunting with rifles and shotguns. So there was a debate on the barrel length, and the prosecution acknowledged that the barrel length of this rifle was more than 16 inches. And so the prosecution was arguing, okay, fine, we're haggling about the details.
Who said, I've seen a lot of this case, but I can put it to the side and still listen to the facts of the trial. The white jurors seemed to move on when the black jurors did not. And so the prosecution made the argument, and the judge, I think you can tell from his facial expressions, his tone, he was very cerebral when he said, the law of Georgia does not allow me to act. He said the first step of seeing whether or not there was bias, he said, I saw it there. I see what you're doing here, defense, but you have given non-race or race-neutral explanations for excluding them. And it almost seemed like he was saying, my hands are tied. I have to agree with you, defense attorneys, and I have to say that these...
The type of arguments that the jury couldn't even keep up with, given the fact that they were multiple hours each.
Interesting. The judge threw out a misdemeanor gun charge, but he will allow the jury to consider some lesser charges. Talk about what those charges are, Molly, and how do you think that changes this case?
Well, with the misdemeanor charge being thrown out, it really changes the landscape of this case. And as you've explained, there was an exception to the misdemeanor count that basically said that if you have a rifle or a shotgun, it has to be short barrel to be illegal, or you have to be at least over 16. And because we know Kyle was 17 at the time, and the state couldn't prove that the rifle was short barreled, the judge did not allow that charge to go to the jury. But we do have these lesser included offenses, right? So less serious offenses that the jury could convict on rather than what's in the indictment. In the indictment now we have 5 felony counts. But I think when you have an incredibly divisive case like this that's incredibly polarizing, sometimes the jury compromises and they convict on those lesser included charges.
Mr. Sheffield, you can agree or disagree with this court, that is your prerogative. But to act in the way that you just did in front of this panel, disrespect, I don't care whether you like my rulings or not, or you like me or not, but in this court, the Superior Court, it is axiomatic that counsel show at least respect for what the court is doing. And what you just did shows a lack of respect for what the court is trying to do here, which is create an environment which is fair to all parties. I would suggest that you take a moment to think about that. I'm going to step off the bench because I found that, I'll just call it rude. Okay? I have tolerated a number of things in the courtroom, including, flip charts, writing in the middle of,
There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
No. From the state. Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. And with all candor, I was not even aware that
the most talked about figures in the Kyle Rittenhouse trial. The 75-year-old has yelled at prosecutors, refused the word victim be attached to those who were shot by Kyle Rittenhouse, let his own phone ring repeatedly during court, and on Veterans Day applauded a defense witness who is a veteran. Many say the judge's actions may be imprinting too much of himself on this trial, but lawyers who have argued cases before him for years say all judges have their own style, and now a national TV audience is getting to know Judge Schroeder, the longest-serving circuit court judge in Wisconsin. There's little doubt Judge Bruce Schroeder is polarizing.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so.